Our next session, starting here at 10 o'clock this morning, as noted from the outset of today's presentations, will go until 10:55. This session is going to address the important topic of professional work visa options. So I'd like to welcome in Jake Muklewicz. Jake is a shareholder in the firm's office and advises multinational corporations, local businesses, individual investors, and professionals in areas involving employment-based immigration law. Jake, thanks so much for joining us today. We're glad to have you. I'll turn the time over to you.
Well, thank you very much. It's my pleasure to be with you all. Looking forward to our immigration session today. And I thought I would just start with a little anecdote before we go into the agenda. It's important to know what our long-term and short-term objectives are. When we're dealing with immigration, when we're dealing with our businesses, I learned a valuable lesson as a teenager shoveling snow for my great aunt. One day I was out shoveling her snow in front of her house, and she called me into the house, and she was speaking Polish with my great aunt in Calgary, Canada. And she said, "Jakub, how do we get to Steubenville? Could you give me directions to Steubenville?" And without listening to the rest of her question, I just immediately answered. I said, "Well, you just get on Route 22. You go west. It turns into Sunset Boulevard in Steubenville, and that'll take you. Sunset Boulevard will continue going east to the Ohio River, and you'll get downtown." And she chastised me. She says, "Jakub, that's what's wrong with you young people, is you're impatient and you don't listen." She says, "I'm talking to your great aunt Stasha in Alberta, Canada. She wants to drive to visit me next summer, and she needs to know how to get from Alberta to Ohio to Cleveland, and then from Cleveland to Steubenville. So it's very important for you to get the full picture. You don't know where you're going to be driving if you don't know where you're starting from. So starting points, gathering information from the very beginning, and knowing our destination are very important when we're talking about different professional work visa options that some of your foreign employees may have. It's very possible that you have a foreign employee that qualifies for multiple visas. So let's take a look at our agenda, see what visas we'll be looking at today. We've got the H1B visa, which many of you may have already heard about. That's a work visa category that's available for any foreign national, regardless of their country of citizenship. It's available for most professional occupations. We'll talk about the procedure and the qualifying criteria for a foreign national to be eligible for an H1B work visa. And then we also have an H1B visa, similar to the H1B, but it's only available for Chilean and Singaporean nationals. Then we have the TN work visa, available for Canadian and Mexican citizens. And then the E3 work visa, available for professionals who are citizens of Australia. So let's go into the first visa, the H1B visa, which many of you may have come across as you're recruiting and employing foreign national employees. The requirements for the H1B are pretty straightforward and upfront. To serve as, a lot of times people use the word sponsor. In the immigration field, we use the word petitioner because that's the word that's used in the immigration statute and regulations. But the company, the sponsor, the petitioning employer must be a U.S. employer. So it's got to be a company that has a valid federal employer identification number. It's registered with the Internal Revenue Service and is doing legitimate business in the United States. The position must be eligible. The worker has to be eligible. H1B visas must be available. The Department of Labor has to certify and approve a labor condition application. And then the U.S. Citizenship and Immigration Services must approve the H1B visa petition. So we're going to go through each of these different criteria and see, what this means. So what does it mean for the petitioner, but for the position to be eligible? The H1B classification is by far the bread and butter that's used by most U.S. employers to get work authorization for a foreign national. So it is used for almost all employers, all industries. It can be used for foreign nationals from any country in the world, and almost for all jobs. If we take a look at the next slide, the employer can sponsor a foreign national for H1B status, as long as the employer has a job, offers a position to the foreign national that requires at least a 4-year bachelor's degree in a field that is related to the occupation. And it's also important that the foreign national, the worker, has the minimum education required. So what does that mean? Let's say that you're an IT or a software company and you have a position for a computer engineer. The position for H1B eligibility would have to require at least a 4-year bachelor's degree in computer science, computer engineering, software engineering, or a field that's closely related to the job. And then the foreign worker would have to have the equivalent of a 4-year bachelor's degree. Now, the employee could have either a 4-year degree from a U.S. university or college, could have a foreign degree that's equivalent to a 4-year bachelor's degree in the United States, or the foreign national may have experience that is equivalent to a 4-year bachelor's degree in the United States. For experience to be equivalent to a 4-year bachelor's degree, the immigration regulations equate 3 years of work experience to 1 year towards a bachelor's degree. So if you have a foreign national that has no higher education, the foreign national would have to have at least 12 years of professional work experience that's related to the position. Because 12 divided by 3 is 4, and the person has to have a 4-year degree. And again, it's important to remember that that degree is related to the occupation. So you may have an individual who you want to hire for a computer engineer, software engineering position, but if they have a 4-year degree in history or a 4-year degree in philosophy, they're not going to be eligible unless they have at least 12 years of work experience. So let's go forward and see what other requirements we have for the H1B. The company has to be, as I had mentioned before, a bona fide company that has an FEIN, and it has to hire the foreign national to be working in the United States. There also has to be an employer-employee relationship between the sponsoring, petitioning U.S. employer and the foreign national that's applying for H1B visa status. And this is a very important issue for the U.S. Citizenship and Immigration Services, as well as for the U.S. Department of Homeland Security, because the federal agencies, the U.S. agencies, don't want U.S. employers to be using the H1B visa category as a way to negatively impact the wages and working conditions of U.S. workers. So there's, we'll talk in more detail, but there's a limited number of H1Bs, and some companies will farm out their H1B workforce to other companies when there's a shortage of H1B visa numbers. And the Immigration Service and the Department of Labor both, want to make sure that the H1B category is being used appropriately. We go to the next slide. A U.S. employer can file an H1B petition, and a U.S. employer can be any of the following. It could be an individual person, firm, corporation, contractor, association, or other legal business entity. So the people who can file H-1B petitions, the organizations that can file H-1B petitions, it's very broad. The main thing to keep in mind is that it's a U.S. employer. It's going to be hiring a foreign national to work in the United States in a qualifying position. We move forward to the next slide. Now, the nature of the H-1B jobs, is important. In the immigration statute and in the immigration regulations, it refers to H-1B positions as specialty occupations. And what that means is that the job must require the application of a highly specialized body of knowledge. And the key point is that the minimum education requirement for the job is a bachelor's degree, a 4-year bachelor's degree or its equivalent, again, in a field that's related to the position. The minimum education requirement, when you file an H-1B petition with the U.S. Citizenship and Immigration Services, how do they know whether or not a 4-year bachelor's degree is required for the job? What the adjudicators at CIS will look at is they'll look at the U.S. Department of Labor's occupational reports that are available in ONET and also in the Occupational Outlook Handbook. And they focus on language where the Department of Labor says most of these jobs require a 4-year bachelor's degree, but some do not. Now, in the past, the U.S. Citizenship and Immigration Service would give employers a pass. And they would look at the ONET, they would look at the Occupational Outlook Handbook, and they'd say, most employers require a bachelor's degree. That was enough. In 2017, after President Trump entered the White House, the Trump administration said, not all of these ONET summaries and Occupational Outlook Handbook summaries say that a bachelor's degree is required for every position. If you read the verbiage carefully, it says most require a 4-year bachelor's degree, but some do not. And the Trump administration put a lot of pressure on the Citizenship and Immigration Service centers to hold employers, petitioning employers' feet to the fire and prove that a 4-year bachelor's degree is really required for the job. So if we look at the other bullet points, in the regulations, an H-1B petition is a specialty occupation, meaning that it requires a 4-year bachelor's degree if the degree requirement is common in the industry and other organizations in the same or similar industry. So what I often do is I'll look at Indeed.com or Monster.com and do very targeted job searches for a position that's similar to the H-1B case that I'm working on. And I use those private industry job ad sites to show the Citizenship and Immigration Service that not only our petitioning U.S. employer requires a 4-year bachelor's degree, but competitors in the field who are recruiting for the same or similar position are also using a bachelor's degree requirement. Another requirement is that if the job duties, the tasks themselves, are so specialized and complex that it just is obvious that you need to have a 4-year bachelor's degree to do the position. So what that means in real world terms is that if an employer has a generic, vanilla, bland job description with very opaque job duties, the Immigration Service is going to look at that and say, this is too general. We don't know if you really need a bachelor's degree to do this position. But if a job description for an H-1B visa petition, if the job description is complex, detailed, shows the percentage of time required to perform each job duty, and if those job duties are so sophisticated and complex that they require at least bachelor's level coursework in a specific major, that lines up with the degree and academic transcripts of the foreign national, that's a much stronger H1B case. And then the final criterion that the U.S. Citizenship and Immigration Service will look at is the petitioning employer's hiring history. If the petitioning employer has always filled the H1B vacant position with people who have at least a 4-year bachelor's degree in a field that's related to the occupation, then that evidence can be used to show that the job requires a 4-year bachelor's degree. And again, since 2017, and even after President Trump left the White House and we now have the Biden administration, the Citizenship and Immigration Service is still holding employers' feet to the fire to prove that a job really requires a 4-year degree. So, you know, if it's been a while since you've done an H1B, if you were doing H1Bs before 2016, they're much more complicated in that the Citizenship and Immigration Service wants to see a lot more evidence that a bachelor's degree is required for the position. So if we move forward, so the qualifications of the H1B worker, that's fairly simple. If the job requires a 4-year degree in computer science or software or computer engineering, then the H1B worker has to have at least a U.S. bachelor's degree or higher from an accredited college or university, or a foreign degree that's equivalent to the U.S. bachelor's degree. How do you prove that the foreign degree is equivalent to a U.S. bachelor's degree? The Immigration Service allows petitioning employers to use independent services of academic evaluators, independent credentialing services that have on staff college or university professors that can look at a foreign degree and make an attestation, an expert opinion that a foreign degree is equivalent to at least 4 years of credit hours in a U.S. bachelor's degree program. We move to the next slide. If the worker, has some education, but they don't have a 4-year degree, the immigration regulations for H1B workers do allow the service to take into account a combination of education, training, and or experience. So we might have a situation where a worker has a 2-year associate's degree in computer science and at least 6 years of experience working as a computer programmer or computer engineer. In that situation, we could get a credentialing evaluation that shows that the combination of an associate's degree, which has a 2-year academic component, plus 6 years of work experience, 2 academic years plus 6 years of professional experience. 6 divided by 3 is 2, so 2 plus 2 is 4. In that hypothetical, the person who has an associate's degree and at least 6 years of experience would still qualify for H1B status. So the take-home message is if a person does not have a 4-year U.S. bachelor's degree, he or she may still qualify for H1B work status. We've got to look at the whole picture. Don't make the mistake of thinking that you get to Steubenville just by going east on Route 22. You've got to know where your starting point is. So it's good to get as much information as possible about the foreign national who is applying for the H1B petition. One of the big drawbacks of the H1B category is that there's a limited supply. There's generally an H1B cap limit of 65,000 new H1B work visas available each year, with an additional 20,000 available for H1B applicants who've obtained a master's or higher degree from a U.S. college or university. The government's fiscal year runs from October 1st to September 30th. If we move to the next slide. Now, there are some exemptions from the H1B cap. Employers who are exempt from the H1B cap, as well as the additional H1B filing fees, are listed on this slide. So government research organizations, nonprofit entities that are related or affiliated to institutions of higher education, those types of organizations are exempt from the H1B cap. If we move to the next slide, it's important to know that if you have an employee, if you're a for-profit private employer, you're not a government research organization, you're not a nonprofit entity that's affiliated with an academic institution, a college or university, you could still get an exemption of the H1B cap numbers if you are affiliated with an exempt entity and you're going to place your H1B worker at an exempt work location. So, what does that mean? That sounds pretty complicated. I used to do a lot of H1B cap exemptions that are based on employment at an exempt location for for-profit, private-owned medical practices. These medical practices would hire foreign national physicians that would be placed to do their work at a medical school, a nonprofit medical school that was affiliated with a university medical system. So even though their employer that was cutting their check and that was directing their employment, even though the petitioning employer was not in its own right exempt from the H1B cap numbers, because they were placing these physicians to work at university hospitals or nonprofit hospitals that were affiliated with universities, they were still exempt from the annual H1B cap numbers. Let's move to the next slide. Now, it's important if you're going to do an H1B to kind of have an idea of when you can file and what your filing deadlines are, when you're going to be facing them. You can file a new H1B petition no more than 6 months before the requested validity period. For new H1B petitions that are filed under the cap each year, I mentioned earlier in the presentation that the government's fiscal year begins on October 1st every year. So the earliest that a new H1B cap petition could be filled would be April 1st, because that's 6 months before October 1. So when you're looking to hire a new H1B worker that's never had H1B status before, you're not in an exempt situation, and you're going to be counted against the annual H1B cap, you want to be scheduling and strategically completing your recruitment, early, in the year after New Year, so that you can play the H1B lottery, which then allows you to file an H1B petition if you're selected in that lottery after April 1st. So what is the lottery? Because there's a limited supply of H1B visas and pretty high demand. 65,000 general H1B cap numbers, 20,000 additional cap numbers available for foreign nationals that have a master's or higher degree, for a total of 85,000. Last year, U.S. Citizenship and Immigration Service received over 300,000 H1B cap petitions. So the supply and demand clearly shows that your chances of getting an H1B are not in your favor. Because the supply doesn't meet the demand, the equitable solution that the government implements to distribute and issue H1B work visas is a registration process, which is also known as a lottery. The way the government does it now is in March of every year, you do an online registration, you give information about your company, you provide information about the employee that you would like to file an H-1B petition for. And if you're selected during that registration process, you're then given instructions by the Immigration Service to file an H-1B petition on or after April 1st of a given calendar year. So if we can move forward to the next slide. Now, in 2019, one of the good things that the Trump administration did in administering the lottery, before the Trump administration, the way the Immigration Service would process CAT cases was on the first, during the first calendar week of every April of every year, the Immigration Service would just allow all employers that wanted to file H-1B petitions to submit the petitions to the Immigration Service. And what would happen is the Immigration Service would receive hundreds of thousands of petitions. The service could only process 65,000 general numbers plus 20,000 advanced degree petitions, and they would have to return hundreds of thousands of petitions back, together with filing fees and stacks of paper that were at least 24 inches thick. It was a waste of time, resources, and money for both the employers and the Immigration Service. And so the Trump administration said that, you know, the electronic registration process would be a way to, at the front end, determine which of the 85,000 applications would be processed, instead of allowing, you know, hundreds of thousands of applications to be processed and only a fraction of those actually going on to the service, to the queue for visa issuance, and then having to send hundreds of thousands of applications back to employers that were waiting several months to find out whether or not they were going to be able to get an H-1B worker. So one of the good things that the Trump administration did is they reversed the process. They're filtering applications at the front end so that people aren't wasting time and resources. And the government, you know, the goal is to help the government reduce its workload so that it could process visa applications more quickly as well. If we could go to the next slide. So under the registration system, the registration typically opens in March, and there's a 14-day window within which people can submit registrations. It's important to understand that when you're registering for the H1B lottery, you can only file one registration per employee. So some people think, well, if I pay the $10 registration fee 10 times, I'll pay $100, but I'll register the same employee 10 times. I increase my chances. The more lottery tickets I buy, the better chances I have of winning the lottery. The USCIS's rules don't allow you to do that. You can only file one registration per employer, per employee. So if you file multiple registrations, because it's an electronic system, the system will notify the Immigration Service that the same employer has filed multiple registrations for the same employee, and you will automatically lose the lottery for violating the rules of one registration per employee. We can move to the next slide. You know, after the registration period ends, the Immigration Service will randomly select. It's not a first in, first out system. It's not a system where some employers have preference over others, but it's a random selection process where the Immigration Service's computer will identify cases that are eligible for additional processing. If you win the registration lottery, then you obtain instructions to file your petition within a certain filing window. And it's important, if you do win the H-1B registration lottery, that you file your petition within the filing window specified by the Immigration Service. Moving forward. Sometimes the Immigration Service still has visas available, there may be some situations where employers win the lottery, but they don't file their petitions, or they file a petition. The visa applicants either withdraw, or they're not eligible because they don't meet the educational requirements. So after the cap has initially been met, the Immigration Service will review its H1B cap visa number issuance, and if there are still visas available, they will accept a second or perhaps even a third round of H1B registration. So if you don't win a registration initially in March, the Immigration Service, if they don't use up all of the numbers, they will go back to the prior registration lotteries, administer the lottery again, and you may win the registration lottery on the second or third round. Typically, you don't have to file another registration. The Immigration Service will just use its computer system to draw from previously submitted but unselected registrations during the initial round, and in subsequent rounds, they'll process those previously filed registrations. Let's go to the next slide. And let's go to the next slide again. Okay, assuming that you win the registration, before you file anything with the U.S. Citizenship and Immigration Services, you must file what's called a labor condition application with the U.S. Department of Labor. The labor condition application, commonly referred to as the LCA, the acronym, basically contains attestations that the petitioning employer is going to use the H1B program in the appropriate way. The LCA may be filed no more than 6 months before the intended H1B employment will begin, and it can be certified for up to 3 years. Why up to 3 years? Because H1B visa status may only be approved for up to a 3-year period. An LCA can be certified for multiple openings of the same occupation. So if you have 10 computer programmers or computer engineers, you can use one LCA for multiple positions. So you don't have to have one LCA for each worker, as long as the workers are fulfilling job requirements and performing job duties in the same position. It's important to understand that the DOL can take several days to process an LCA. So if you do win the H1B lottery registration, you don't want to wait until the last day to start preparing and filing your H1B petition, because it might take the Department of Labor up to 2 weeks to certify an LCA. Typically, if you win the H1B lottery, they give you a 2-month filing window to prepare and file your H1B petition. My advice is always, if you win the lottery, start preparing and file as soon as you can, because you don't want to run out of time, especially if you're depending on the Department of Labor to quickly turn around an LCA. In the old days, meaning 15 years ago, LCAs were certified within a matter of 30 seconds. You would think with the advent and with the advances in computer technology that LCAs could be certified much more quickly. That's not the case. LCAs have to go through quality controls that require human beings to look at things, and so that's why the process now takes a little bit longer. So if you have to do an LCA, keep in mind it might take up to 2 weeks to get an LCA certified by the Department of Labor. Okay, moving on. The LCA has to identify, the job, has to identify the number of H1B workers that are going to be using that specific LCA. You have to provide wage information, the validity period, the work period that the employee is going to work at that position, the place or places of intended employment. This is very, very important. Please keep in mind that for an H1B visa petition is specific to the employer, it's specific to the job, and it's also specific to the area of employment. During the COVID-19 pandemic, a lot of well-intended employers are allowing their employees to work from home. You can do that with an H1B worker, but if your H1B worker is working from home and that home residence is outside of the metropolitan statistical area that's certified under the LCA, which is part of the H1B petition, you're violating the terms and conditions of the approved H1B status. So if we're going into another situation in the future where the pandemic or other economic reasons may cause employers to allow workers to have more flexibility, if you have someone with H1B work status, H1B1 work status, or the E3 status, all of these visas that we're gonna talk about, if they have an LCA component to it, if they're working from home, you must make sure that you have an LCA that covers their residential address. If not, then you have to file an amended petition, and the LCA has to cover the home work site. Again, this bites employers when they file extensions, and when you file an extension, you have to provide pay stubs, pay information to the Citizenship and Immigration Services, and if they see information, evidence in the file that the employee was working from home and that home work site was outside of the certified LCA, then you violated the terms and conditions of the status, and their extensions may be denied, and they may be getting, in lieu of an approved extension, they may be getting a denial letter with a notice to appear in front of a deportation judge. So do pay attention to your work sites, especially if you're allowing flexibility with working from home. So let's move to the next slide. I mentioned that the employer makes various attestations when you're filing an LCA with the Department of Labor, and each of these attestations is under the penalty of perjury. So the employer promises that it's going to pay the H1B worker the higher of its actual wage or prevailing wage. What does that mean? Let's say the prevailing wage for a position is, the Department of Labor says for a computer engineer in Salt Lake City, for an entry-level position, you must be paying at least $60,000 for an entry-level position. If your company pays $70,000, then there's not a prevailing wage problem, but you do have to make sure that you're paying the H-1B worker $70,000 if you're paying all other entry-level people $70,000. So let's use a different hypothetical situation. Again, let's say that the prevailing wage is $60,000, but your company follows market conditions and is paying entry-level people $55,000 to fill an entry-level position. If you want to file an H-1B petition with the Immigration Services, you're going to have to increase that H-1B worker's wage from $55,000 to $60,000. And when you file the LCA, before you file the LCA, you have to post that LCA with the prevailing wage requirement to your U.S. workforce. What does that do? It allows the U.S. workers to see that a foreign national is being hired for the job that they do, and that the foreign national is going to be making more money than they are. And what the public policy behind this LCA and the posting is to give U.S. workers notice about a foreign worker that may affect their wages and working conditions. The public policy is supposed to increase wages for U.S. workers. So if people are playing by the rules, contrary to what you see in the news and what you hear in press reports and what you hear from some politicians, if the H1B visa program is done the right way, it increases U.S. workers' wages, not decreases them. The second attestation is that the employer is going to offer a job with the same working conditions to the H-1B worker that's provided to U.S. workers. The third attestation is that the company is not using the H-1B worker to replace striking or locked out U.S. workers. And the fourth and final attestation is that the worker has provided notice to its employees or the union bargaining representative if there's a unionized workforce. So moving on. After you get the LCA certified with the Department of Labor, the next step is to prepare a petition to file with the U.S. Citizenship and Immigration Services. It's the standard form for a non-immigrant visa petition is Form I-129, and the petition is generally filed with the USCIS office that has jurisdiction over the place of employment. Always, always, always refer to the USCIS's website and see if service centers have changed jurisdictions, or if they're only accepting certain petitions. During the pandemic, the government has had to shift operations and has changed the filing addresses on various petitions. So a good rule of thumb is to always, before filing a petition, consult with the Citizenship and Immigration Services website, look at it, review it, and make sure that you're filing at the appropriate, up-to-date service center. Next slide. Here's a list of documents that have to be included in the H-1B petition. I'm not going to read through them, but you have that for your future reference. Again, I mentioned that H-1B petitions are pretty thick, so it's not just a couple sheets of paper. I mean, you've got a couple feet of government forms and supporting documentation that are submitted to the Citizenship and Immigration Services. Next slide. Well, let's go to the next slide. Okay, if there's a license required for the occupation, you have to pay special attention to your timing of when you file the H-1B petition. So if a license is required for the petition, make sure that your H-1B applicant has the license before you file. It does no good to file an H-1B petition for a job vacancy that requires a license, but your visa applicant, he himself or herself doesn't have the license. Also, make sure that the worker, if you're filing for someone who's in the United States and they're doing either an extension or a change of status petition, make sure that your individual for whom you're filing has valid status. Again, it doesn't do any good to get a petition approved, but the foreign national is out of status. The only way for them to get the H-1B visa status is to go to their home country to apply for an H-1B travel visa. But if they've been out of status for more than 6 months, they're not going to be able to return to the U.S. for 3 years. And an H-1B can only be approved for up to 3 years. So it's good to do due diligence in knowing the status of your employee. So let's move on. Acquiring H-1B status. If the worker is in the U.S. and the petition is approved as a change of status or an extension of status, then once the Immigration Service approves the H-1B petition, the H-1B status becomes effective as of the approval date. If the foreign national is outside of the country, they'll have to use the approval notice to go to a U.S. embassy or consulate to obtain a travel visa to come to the United States. During the COVID-19 pandemic, it's very difficult to get visa appointments because the embassies and consulates have been understaffed, not operating for several months, and there have been tremendous backlogs at embassies and consulates. So do keep that in mind if you're filing an H-1B for someone out of the U.S. Let's move to the next slide. H-1Bs can be approved for up to 3 years. There's typically a 10-day grace period that's granted by the Immigration Service on the back end. But it's always, always make sure that you look at the approval notice and the I-94 admission cards anytime a foreign national travels in the United States. With the last in time rule applies. So if you have an approval notice that's good for 3 years, but an H-1B worker travels, they come back in, and because their passport is expiring within 6 months, a lot of times Customs and Border Protection officers at the port of entry will only admit an H-1B worker or an H-1B1 or a TN or an E3 worker only for the validity period of their passport. So anytime your foreign employees travel, make sure that you're getting copies of their I-94 admission cards. Don't assume that their period of admission will always coincide with their 3-year approval from their H-1B petition. So let's move forward. When you file extensions for people who are in the United States in H1B status, it's good to know that if you file a timely extension, because the Immigration Service is taking such a long time, if you file an extension before the foreign national's status expires, you'll get a 240-day extension period, and that's in the immigration regulations. So we can move to the next slide. The maximum period of stay, typically an H-1B worker can only get up to 6 years. There are exceptions. If you start the green card process, you file a perm labor certification application, that perm application has been processing for at least 365 days, you're then eligible to file post 6-year extensions for the H-1B worker until you get a final decision on the employment-based green card petition. Let's move to the next slide. And that's, if the other extension you can obtain beyond the 6 years is after you get an I-140 immigrant petition approved. If the immigrant visa category, the green card category, is backlogged, you can extend the H-1B status in 3-year increments beyond the 6-year limit indefinitely, again, until there's a final decision on the green card. Let's move to the next slide. Family members of H-1B workers are eligible for an H-4 dependent visa. That's for a spouse. Unmarried children up to 21 years. The H-4 visa allows the dependent family members to live in the U.S. and to attend school, but it does not allow them to work. Beginning in 2015 May, certain H-4 spouses are eligible to work. If the H-1B worker is the beneficiary of an approved I-140, that's part of the employment-based green card process, or has been granted an extension beyond the 6-year limit, then the H-4 spouse is eligible for an employment authorization document. Okay, we're going to go through these next visa categories very quickly. They're basically subsets of the H-1B. The H-1B one is the H-1B category, but for Chilean or Singaporean citizens. So everything that we talked about, the H-1B applies for the Chilean and Singaporean professionals, but they get special carve-outs of the H-1B cap because there are trade agreements between Chile and Singapore. So you still have to have a position that requires a 4-year degree in a field related to the occupation. They have to have the education. You file the LCA. You go through the same process. The H-1B one is almost the same as an H-1B, except it's specifically for Chilean or Singaporean nationals. So let's go to the next slide. A few of the differences: the H-1B one validity period is valid for up to 18 months as opposed to 3 years. The maximum stay is 6 years, but you're going to be filing extensions more frequently for H-1B1 workers from Chile and Singapore because they only have an 8-month max out on an initial approval. Let's go to the next slide. The TN, this is underutilized by a lot of recruiters and companies. The TN is for Canadian and Mexican citizens who will fill positions that are considered professional under the former North American Free Trade Agreement, NAFTA, which has been replaced by the US-Mexico-Canada Agreement. Even though the USMCA has replaced NAFTA, there's still within the TN regulations references to the NAFTA. The NAFTA has been incorporated by the USMCA. What you need to check for TN visa eligibility is the potential hire a Canadian or Mexican citizen, and is their position covered under the appendix, the NAFTA appendix for professional occupations. The NAFTA appendix will tell you what occupations are eligible, and they will also tell you what education or experience requirements the foreign nationals must satisfy to be eligible for the TN category. People can apply for the TN either inside the United States by filing form I-129, or they can file directly in the case of Mexicans at a U.S. embassy or consulate. Canadians are visa exempt. They don't need to have a TN travel visa to enter the United States. So they can submit their TN petitions at a port of entry or a pre-flight inspection station at a Canadian airport where there's a U.S. immigration office. Let's move to the next slide. The advantages of the TN category that are often overlooked. A TN applicant doesn't need prior USCIS petition approval. Again, you don't need to file 2 feet of paperwork with the Citizenship and Immigration Service. You can give a reduced file to either the embassy or consulate in the case of Mexican applicants, or Customs and Border Protection officers at a U.S. pre-flight inspection office at a Canadian airport or at the U.S.-Canadian land border. No LCAs are required, so that you don't have these attestations that you're not going to jeopardize or adversely affect U.S. workers' wages or working conditions, and you don't have to post to your U.S. workforce how much money you're going to be paying your visa applicant. The big thing here is there's no annual cap, so you don't have to worry about the lottery registering. Are you going to be one of the lucky lottery winners? The supporting documents for TN status listed on the slides. Feel free to refer to those as you're reviewing the materials. Let's move to the next slide. The validity period is for up to 3 years. Typically, the Immigration Service will allow TN workers to continue working in the United States for up to 6. One of the key disadvantages to the TN category is that you don't get post 6-year extensions. Even though there's no maximum time limit, the TN category does require the foreign national who's applying for the visa to show that he or she has a permanent home either in Canada or Mexico that they're going to return to when they've completed their temporary assignment in the U.S. So once you get beyond 6 years of TN status, unless the TN worker is a commuter, meaning that he or she lives in Canada or Mexico and is driving into the United States to work every day, if you're working in the interior in the United States, which would include Utah, where you don't have an easy commute from Canada or Mexico to your job site, you're going to run into problems after 6 or 7 years of TN status. Let's go to the next slide. Family members get TD dependent visas, again, which allow them to live and work in the United States, to live and study in the United States, but does not allow them to work. So TD dependents cannot work in the United States. Let's go to our final category. The E3 category is basically the H1B, but for Australians. So there's a 10,000 annual E3 cap. That cap has never been reached. To apply for an E3 work visa for an Australian citizen, you do not have to file anything with the Citizenship and Immigration Services. So if you have someone who's in Australia or anywhere else in the world, as long as they're an Australian citizen, they could go right to a U.S. embassy or a consulate, again, assuming that consulates and embassies are operating normally, and they can apply for the E3 visa. The eligibility category requirements, the LCA requirements, they mirror those of the H1B, which we talked about. So if you understand how the H1B works, you'll understand the E3. It's H1B light, but for Australians. So as you're looking at various work options, it pays to ask your potential hires, do they have multiple citizenships? Do they have dual or multiple citizenships in other countries? If the H1B cap is used, you may have some exemption arguments and possibilities. If you have people from countries that have specific agreements with the United States, Chile, Singapore, Canada, Mexico, Australia, you'll have some additional work visa options. So, ask questions, get as much information as you can as you're going through the recruitment and hiring process, so that you don't paint yourself into a corner and say, well, H1B is a long shot, the odds are against us. you may be missing out on some opportunities to get some really good talent. And that being said, if knowing that the H1B category has an artificial cap, I always instruct and encourage my employer clients to recruit in areas and countries where there aren't any artificial caps. So the TN category has no annual limits. If you can get great workers from Canada and Mexico, it's well worth your while to try to recruit there. And with that, I thank you for your time and attention. And if you have any questions, always feel free to look at the slides and to get in contact with competent immigration counsel.
Jake, thank you very much for being with us today. That's a lot to unpack. Thanks for taking us through or helping us navigate the H1B visa process and all the implications that are associated with it. If you have any questions, as Jake mentioned, please feel free to reach out to him directly. His contact information is shown on the screen here. Okay, we will take another break and we will resume in 4 minutes at 11 a.m. with our final presentation of the day. We'll see you soon.